Hey guys, welcome to our video. This is part 9 of our series on the FDCPA, the Fair Debt Collection Practices Act. And it's a very important section, and a lot of people know at least something about this, and that is 1692G, validation of debts. So we're going to look at just this section in today's video. So it starts off, Section A, it says Notice of Debt Contents. So within 5 days after the initial communication with the consumer in connection with the collection of a debt collector shall. That means this is not advised, this is not a suggestion, this is not a good idea. A debt collector must 100% of the time do this unless the following information, we'll see it on the next slide, is contained in the initial communication. Because remember, what triggers this is within 5 days after the initial communication. Now, if that initial communication contains all this, then they're good. Or the consumer has paid the debt, so you could call the consumer and the consumer pays it, well, then you wouldn't have to send this as a debt collector within 5 days. It says send the consumer a written notice. So this is not just calling them on the phone. This is a written notice containing, and now let's look at the 5 things. So number 1, the amount of the debt. Number 2, the name of the creditor to whom the debt is owed. So it could be we're dealing with a debt collector that is collecting for Capital One, or it could be a debt buyer. And sometimes it gets a little tricky as when debt has been bought and sold several times, but clearly that they've got to list who the creditor is. And again, we'll see when we go through some case decisions what exactly that means, a creditor. But number 3, it's got to tell the consumer that unless within 30 days after receipt, so not 30 days after the date of the letter, unless it's hand delivered, but 30 days after receipt, if the consumer does not dispute the validity of the debt will be assumed to be valid by the debt collector. We'll come back to that in a moment. Number 4, if the consumer notifies the debt collector in writing, so this is not verbal, this is in writing, within that 30-day period that the debt or a portion of it is disputed, the debt collector will obtain verification of the debt or a copy of the judgment against the consumer, and a copy of such verification or judgment will be mailed to the consumer. So let's kind of unpack that a little bit. So we've got this 30-day period. And if the consumer tells the debt collector in writing, hey, I dispute the whole debt or a portion of the debt, then the debt collector will get verification of that debt, or maybe there's a judgment out there. Well, why would they get the judgment? Because the judgment shows you that you owe the debt. If a judge says you lose this lawsuit, you owe the debt, that's about the best kind of proof there is. And so it'll get that, but not just that the debt collector will get that verification or that copy of the judgment, but it will mail that to the consumer. Again, not just call them on the phone and say, hey, we got this judgment, you can go look it up. They've got to mail it to the consumer. And then number 5, a statement that upon consumer's written request within 30-day period, debt collector provide the consumer with the name and address of the original creditor if different from the current creditor. So the current creditor might be Midland Funding. Let's say that they claim to own the debt, but you say, well, who was the original creditor? Well, they have to tell you that. And the debt collector has to say, look, you can request this from us. Well, let's go on to subsection B, disputed debt. So what happens if within that 30-day period the consumer disputes a debt? Now, keep in mind, if we go back a couple videos to 1692E8, that tells us if a debt is disputed, the debt collector has to show that on the credit report. That is not limited to this 30-day time period. That's any time the debt collector, and that can be done verbally. But this is specifically under this section called validation. 1692GB says if the consumer notifies the collector in writing within that 30-day period that the debt or a portion is disputed, or the consumer requests the name and address of the original creditor, then the debt collector shall, again, not a suggestion, not this is a good idea, you shall, 100%, shall cease communication of the debt or any disputed portion thereof So what that means is, let's say a debt collector writes me and says, John, you owe $1,000 in principal and $200 in collection fees. And I say, well, I admit I owe the $1,000, but I do not owe the collection fees. I dispute that. Well, then they would have to cease collection of the disputed portion, the $200. But if you just dispute the whole debt, they've got to cease collection of the whole debt until the debt collector obtains verification of the debt or a copy of the judgment or the name and address of the original creditor. So in other words, whatever it is that you've disputed, you dispute the debt, you dispute the name and address of the creditor, you dispute that there's a judgment, whatever it is, they've got to send that to you. And it says mailed to the consumer by the debt collector. So what this means is you get a letter or you get any communication from a debt collector, and it's within that first 30 days of it, and you tell them in writing, I dispute this. They have an option. They can either get you what you dispute, and we'll come back to that in a second, but they can get you what you dispute, or they can just stop collecting. So a lot of times there's confusion. People say, well, I sent a debt validation letter and they didn't respond. I want to sue them. Well, if they stop debt collection, that's okay. So they either have to get the proof, and again, we'll come back to that in a second, what that means, get the proof, or they have to stop collecting. What they're not allowed to do is ignore your validation request and continue to collect. And so it's just saying, look, go get that, mail it to the consumer. And then it says, collection activities and communications that do not otherwise violate this subchapter may continue during the 30-day period referred to in subsection A unless the consumer has notified the debt collector in writing the debt is disputed or they ask for the name and address of original creditor. So just saying, if, again, I get a phone call from a debt collector, next day they mail me out what's called the 1692G notice, which is what we're talking about here. Until I dispute that in writing, they can continue to collect the debt. But once I dispute it in writing, now they've got to stop and go get verification of the debt or a copy of the judgment or the name and address of the original creditor. And then picking up here at the last part of this is any collection activities or communication during the 30-day period may not overshadow or be inconsistent with the disclosure of the right to dispute the debt or request the name and address of the original creditor. So that would mean if they tell you you can dispute, they tell you you can get validation, they tell you you can get the name and address of the original creditor, but then maybe the next paragraph overshadows that and just makes it like, it's almost like disregard that warning we gave you. You really don't have that right. Well, then that would violate this law. So they can't put your rights about you have the right to dispute, request, name, address, original creditor, etc. They can't put that in tiny little font and then put in big font like, we will make your life miserable if you don't immediately pay that. Well, that would be overshadowing this. So let me come back to this idea of what kind of proof do they have to give you? And we'll see this in some cases when we go through some case law. But there's this idea that you can demand everything possible about this debt. And, I want every receipt, every credit card. They don't have to give you that. If you dispute in general, then they can respond in general. And it can literally be as easy, some courts have said, as they go back to the original creditor. Hey, does John Watts owe this? Yeah, he owes it. Okay. They've, have, quote, verified the debt. But the more specific you are, then the more specific they're going to have to be in their investigation and their verification. So if you say, wait a minute, you say I owe $1,500. I made a $250 payment 6 weeks ago and I used this check number and it cleared the bank on this day. They can't just come back and go, yeah, we checked and you owe. No, you got to respond to my very specific dispute. So that debt collector would have to say, well, actually, we did not get that check, or the original creditor did not get that check. So just think of it. You sort of control how much detail they're going to have to bring back to you, and that's controlled by how much detail you put into the dispute. Now, sometimes you get a phone call, you get a letter from a company, and you say, I honestly have no idea who these people are or what they're doing. We'll just dispute in general. And then once you start getting some more information, then you can kind of tailor that dispute. But other times, Like, you get a bill from a debt collector and it's a $500 copay for a surgery you had, and you're like, I paid that. I absolutely paid that. Here's the credit card receipt, or here's the canceled check. Well, then you would be very specific in your dispute, in your, quote, validation request. Okay, well, let's go on. This will finish up this section 1692G. This is very, very important, this subsection C, admission of liability. The failure of a consumer to dispute the validity of a debt under this section may not, let me emphasize that, may not be construed by any court as an admission of liability by the consumer. Now, I think every collection lawyer at some point has argued exactly the opposite of this. They say, well, Judge, we sued this consumer and we gave them the 1692G validation. No, they did not dispute within 30 days, so they've admitted they owe it. No, Congress specifically says you cannot make that argument. They also do the same in the truth in lending context, but we'll stay focused on this. It's very, very important to keep in mind. You sort of lose some rights, if I can say it that way, by not disputing within the 30 days, not doing it in writing. But the debt collector does not gain any rights by you doing that. It's just they can assume it's valid and continue to collect it. So look at subsection D, legal pleadings, communication form of a formal pleading. That's like a lawsuit, a complaint, a statement of claim, whatever your court calls it. And a civil action shall not be treated as an initial communication. So in other words, there used to be the idea that if you get a lawsuit, that's a communication, so they got to put 1692G notice in there. And a lot of collectors still do that, but that's not required. This now makes it clear that that is not a requirement. E doesn't have a whole lot of application to us, but I do want to point out, let me just summarize it first, then we'll look at it specifically. So you do that dispute within the 30 days, you do it in writing. Well, they've got to stop collection activity until they verify the debt. But what if there's another federal law that says to the debt collector, you must send out certain communication? Well, then they're not going to violate this law. In other words, we're not going to put them in a position where you either have to violate the FDCPA or violate this other law. So this says the sending or delivery of any form or notice which does not relate to the collection of debt and is expressly required by the Gramm-Leach-Bliley Act, or any provision of the federal or state law relating to notice of data security breach or privacy or any regulation shall not be treated as an initial communication in connection with debt collection. So it's just the idea that we're not going to put the debt collector in this bad spot where by following one law, they're violating another. And we're not going to treat that as initial communication that would then trigger this requirement. Remember, within 5 days of the initial communication, they have to do 1692G. Well, they don't have to do that. And most courts say if you write and dispute within that 30 day, in other words, you request validation, they can still send this type of stuff. So I hope that this is helpful. I know some of you guys have been watching this all the way through, and that's amazing. We're on part 9 here. The next section will be very short, and then we'll have some more sections that we'll talk about when they sue you, talk about where they have to sue you, and then talk about when you sue them, what damages can you get. So that's kind of a fun part to go through. So if you have any questions or comment, put those below, and thanks again for watching this, and I'll see you in the next video. Thanks. Bye.